All About Protection of Human Rights Act 1993 by Shivani Johri. Introduction. India is a party to international covenant on civil and political rights and the international covenant on economic, social and cultural rights adopted by the General Assembly of United Nations on 16 December 1966. India is a signatory to a aforesaid convention, and the human rights embodied in the said conventions are substantially protected by the Constitution. However, these there has been growing concern about issues relating to human rights in India and abroad, and having regard to the changing social realities and emerging trends in the nature of crime and violence. The government has been reviewing the existing law and system of administration of justice. Wide-ranging discussions were held at various fora, such as the Chief Minister's Conference on Human Rights, and seminars were organized in various parts of the country, as a result of which the President promulgated the Protection of Human Rights Ordinance 1993 under Article 123 of the Constitution of India on 28 September 1993, and further. It was replaced by Protection of Human Rights Bill 1993 in the Lok Sabha, which paved way for the present Act. The National Human Rights Commission in India is an autonomous body public body constituted on 12th October 1993 under the Protection of Human Rights Ordinance of 28th September 1993. The Act is legislated to establish the National and State Human Rights Commission. The Act gives immense power to the Commission in furtherance of prevention of violation of human rights. When did the Protection of Human Rights Act 1993 came into force? The Protection of Human Rights Act 1993 was enforced on 28 January 1993 after having a deliberate discussion on the subject of Human Rights Commission Bill 1993 was introduced in the Lok Sabha on 14th May 1993 and was referred to the Standing Committee of Parliament on Home Affairs in view of urgency of the matter. Protection of Human Rights Ordinance 1993 was introduced on 28 um, September 1993 by President of India. Later on 8 January 1994, the Protection of Human Rights Act was enacted, which extends to whole of India. What do you mean by the term human right? In terms of Section 2 of the Protection of Human Rights Act 1993, human rights means the rights relating to life, liberty, equality, and dignity of the individual granted by the Constitution or embodied in the international convention and enforceable by courts in. What are the main objectives of the Protection of Human Rights Act 1993? The main objectives of the Protection of Human Rights Act 1993 is protecting human beings from violations. Without human rights, there would be either no if or meaningless life. The rights relating to life, liberty, equality, and dignity of the individual as guaranteed by the Constitution are also included in the category of human rights. Human rights are the rights and freedom of all beings. The purpose of securing human rights as such is to provide protection to these rights against the abuse of power committed by the organs of state to establish institutions for the promotion of living conditions being begins and for the development of their personality, and at the same time to provide effective remedial measures for obtaining redress in the event of these rights are violated. The Act provides for establishment of National Human Rights Commission, State Human Rights Commission, and Human Rights Court, which seek to prevent and punish any gross violation of human rights. Mention in brief the historical background of Protection of Human Rights Act 1933. The West countries, America in particular, critics India on the violation of human rights by Indian armed forces and paramilitary forces, especially in the state of Jammu and Kashmir. In the early 1990s, India felt the need for establishing a Y Commission on as a positive response to the criticism for the foreign government to in the extent of political unrest and violence in Punjab, Jammu and Kashmir, the northeast and Andhra Pradesh. Though it is now a well recognized fact that mm, terrorism is a serious violation of human rights. America never missed the opportunity to criticize India whenever India secured security forces sought to deal sternly with extremists and ultras. In addition to the pressure from foreign countries, there was a strong demand from the domestic front as well for the creation of a national human rights commission. All these led the government to enact a law to establish a human rights commission. The government's proposal to establish the commission was of course sudden without due deliberation. The President of India on September 27, 1993 promulgated an ordinance for the creation of a national human rights commission. Justice Ranganath Mishra, the former Chief Justice of India, was appointed the chairperson of commission on October 12, 1993. Justice M. Venkatachalya, the former Chief Justice of India, assumed office on November 26, 1996, as the chairperson after the retirement of Justice Ranganath Mishra. Justice J.S. Verma, the former Chief Justice of India, became the chairperson on November 4, 1999, when Justice Venkatachalya attained the age of 70 years. After the retirement of Justice J.S. Verma on January 16, 2003, the former Chief Justice of India, Justice A.S. Anand, was appointed the chairperson of the commission. What are the key provisions of the Protections of Human Rights Act 1993? Under Chapter 2 of the Act, the National Human Rights Commission is defined under Section 2, Subclause C, and established under Section 3 of the Act. The Commission shall be constituted of members as laid under provisions of Section 3, Subclause 2, which lay that there shall be a person who shall be treated Chief Justice of India. Um, Two members who have been a judge in the Supreme Court, and other members shall be Chief Justice of a High Court. High Court. Apart from this, there shall be two members who have worked in the field of human rights. Apart from commission, there shall be a national commission for minorities and national commission for women. The members of commission shall be appointed by the president after obtaining recommendation from prime minister for appointment of chairperson, and the members shall be appointed in consultation with a speaker of the house of the people, ministers in charge minister in charge of the Ministry of Home Affairs, leaders of the opposition in the House of the People, leaders of the opposition in the Council of States, and deputy chairman of the Council of the State. The chairperson shall hold office till a period of 5 years or till obtaining 70 years of age, whichever is earlier, and the members shall be hold office for 5 years and shall be eligible for reappointment. The Act also regulates the condition of services, salaries, allowance, and appointment and of additional staff. Chapter 3 of the Act deals with power and functions of the commissions dealt in Section 12 to 16. The commission is granted power to suo motu took into matter concerning violation of human rights. The commission shall also take action in case where victim has filed an application for violation of human rights. The commission shall be deemed to be a civil court for all the purposes of Section 195 and mm, Chapter 26 of the Code of Criminal Procedure 1973. The Commission is best owed with investigation powers while taking help of government officers under Section 14. Chapter 4 deals with the procedure after a complaint has came into notice of Commission. The commission shall, after mm, receiving a notice of violation of human rights, shall inquire into the matter. What is National Human Rights Commission, and what are the main functions of the commission? Section 3 of the act provides the central government shall constitute a body known as the National Human Rights Commission to exercise powers conferred upon the assigned to it under the said act. The National Human Rights Commission of India is an autonomous public body constituted on 12 October 1993 under the Protection of Human Rights Ordinance of 28 September 1993. It was given a statutory basis by the Protection of Human Rights Act 1993 TPHRA. The NHRC is the National Human Rights Institution responsible for the protection and promotion of human rights defined by the Act as rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution are embodied in the international covenant. The commission shall perform all or any of the following functions, namely inquire or its own initiative or on petition presented to it by victim or any person on his behalf into complaint of violation of human rights or abatement or negligence in the prevention of such violation by a public servant when any proceeding involving any allegation of violation of human rights pending before a court with the approval of such court visit under instrument to the state government, any jail or any other institution under the control of the state where persons are detained or lodged for purpose of treatment, reformation, or protection, to study the living condition of the inmates and make recommendation thereon, review the safeguard by or under the constitution or any law for the time being in force for the protection of human rights, and recommend for their effective implementation, review the factors including acts of terrorism that inhibits the enjoyment of human rights, and recommend appropriate remedial measures for treaties and treaties and other international instrument on human rights, and make recommendation for their effective implementation, undertake and promotes research in the field of human rights, spread human rights literacy among various sections of society, and promote awareness of the safeguard available for the protection of these rights through publications, the media, seminars, and other available means, encourage the efforts of non-governmental organizations and the institutions working in the field of human rights. Such other functions it may consider necessary for the promotion of human rights. Who all are the members of National Human Rights Commission and what are its power? The NHRC consists of a chairman, one member who is or has been a judge of the Supreme Court of India, and one member who is or has been the Chief Justice of High Court, two members to be appointed from among persons having knowledge of a practical experience in matter relating to human rights. In addition, chairperson of four national commissions of service as ex officio members. Current members, the current chairpersons of the NHRC is KG Balakrishnan, and other members are Justice Sri Sarik Joseph, Justice Sri D Murugesan, Sri Sarad Chandra Sinha, ex officio member Sri Wajhat Habibullah, Chairperson National Commission for Narrative Channel, Chairperson National Commission for Scheduled Castes, Dr. Rameshwar Oron, Chairperson National Commission for Scheduled Tribes, Mamta Sarman, Acting Chairperson National Commission for Women. Section 13 of the Act provides for the powers of the Commission, powers of a civil court while trying a suit under Code of Civil Procedure under Procedure 1908 to require any person to furnish information on such points or matters subject to any privilege which may be claimed by the by that person under any law for the time being enforced enter into any building or place where the commission has reasons to believe that any documents relating to the subject matter or injury may be found and may seize any such documents or make extract or copy therefrom subject to the provision of section 100 of criminal procedure act code 1973. What powers have been vested in the commission related to inquiries? While inquiries into complaints under the act, commission shall have all the powers of a civil courts trying a suit under the code of civil procedure 1908, and in particular the following, namely summoning and enforcing the attendance of witness and examining them on oath, discovery and production of any document, receiving evidence on affidavits, requisitioning any public record or copy there from any court of office, issuing commissions for the examination of witness or document any other matters which may be prescribed. What are the types of complaints dealt by the commission, and what is the procedure handling such complaints? The commission from its date of its inception and handle various type of complaints which includes respect of police administration failure in action taking action, unlawful detention, false implication, illegal arrest, custodial violation, other police exercise, custodial death, encounter death, atrocities are SC, child labor, dowry demand, abduction, rape and murder, sexual harassment and indignity to women, exploitation of women. A complaint may be English or Hindi or any language from the 8th schedule of the Constitution. Complaints are to be self-contained. No fee is levied on complaints. Complaints may be made by any means, by letter, telegram, or fax, and also on the mobile number of the commission. All complaints must which are received in which whatever shall shall be registered and assigned a number and placed for admission as per the special and general direction of the chairperson, not later than 1 week on receipt thereof. Every attempt should be made to disclose a complete picture of the matter leading to the complaint, and the same may be made in English or Hindi to enable the commission to take immediate action to facilitate the willing of the complainant. The commission shall, however, entertain complaints in any language included in the 8th schedule of the Constitution. It also shall be opened to the commission to ask for further information and affidavits to be filed in support of allegations whenever considered necessary. The commission shall have power to dismiss a complaint in line upon admission of a complaint. The commission shall have power to inquire into the matter by it or that it should be investigated by any authority. The secretariat shall call for protection of or comments from the government authority concerned, giving the latter a reasonable time. Therefore, on every complaint on which the chairperson of the commission takes a decision or either hold any inquiries or investigations. Regulation 8 Regulation 8 of the National Human Rights Commission Procedure Regulation 1994 lays down the following procedure for dealing with complaints of alleged violation of human rights. All complaints in whatever form received by the Commission shall be registered and assigned a number of placed for admissions before a bench of two numbers constituted for the purpose not later than 2 weeks of recipient thereof. Ordinarily, complaints of the following nature are not entertainable by the commission: in regard to event which happened more than 1 year before the making of complaints; with regard to matters which are sub judice, which are vague, anonymous, or pre pseudonymous, which are of frivolous nature, or those which are outside the purview of the commission. The commission's The Commission shall, after receiving a notice of violation of human rights, shall inquire into the matter. The state or central government shall inform commissions of any such violations. Increase there in no such notice from the government of the commission shall see moto look into the matter where the inquiry discloses the commission of violation of human rights or abatement thereof by a public servant. It shall notify the government and demand compensation to complaint and initiate proceeding against such officer. Commissions may also approach judicial courts for any direction such as writs, order, etc. Recommend government authorities to look into the matters and initiate relief to the victim. The commission shall make a report on inquiry and send the same to the concerned authority. Commission under section 19 is granted special power with respect to human rights violation made by armed forces. What is the state human rights commission? How it is constituted? Section 21 of the act provides for the establishment of state human rights commission headed by chairperson who shall be retired chief justice of high court. There shall be one other member who shall be a judge either in high court or district court. The state commission shall inquire only into matter listed in list 2 and list 3rd of 7th schedule. The chairperson of commission shall be appointed by the chief minister. The members shall be appointed by speaker of legislative assembly. Members minister in charge of department or home and leader of opposition. The members shall be appointed for a period of 5 years. Thus, state shall appoint other officers as it deems necessary. The state commission from time to time submits a report on matters of concern and urgency. The state commission shall submit an annual report to the state government and may at any time submit special reports on any matter which in its opinion is of such urgency or importance so that it should not be deferred till submission of the annual report. The state government shall cause the annual and special reports of the state commission to be laid before each house of state legislature, where it consists of two houses, where such legislature consists of one house. Before that house, along with a memorandum of action taken are proposed to be taken on the recommendation of the state commission and the section for non-acceptance of the recommendation if any. What is the work of human rights court under section 30 of the act? Human rights court is also established under section 30 of the act for the purposes of providing speedy trial of offences arising out of violation of human rights. The state government will specify for each district a court of section to be human rights court. A special public prosecutor shall be appointed to try such cases, provided that nothing in this section shall apply if a court of session is already specified as a special court or being a special court is already constituted for such offences under any other law for the time being in force. How does the central and state government facilitate the work of the human rights organization? The central and state government shall provide the commission with grant of which the state and the national commissions shall maintain proper accounts on which shall be audited by auditor general. The commission shall not inquire into matters pending in state commission. The state and central from time to time shall make rules of regulations of for the commission, who is the Controller and General of India. What is the role of NHRC and State Human Rights Organization? The Controller and Auditor General of India is an authority established by Article 148 of the Constitution of India, which audits all receipts and expenditure of the Government of India and the state government, including those of bodies and authorities substantially financed by the government. The CAG is also the external auditor of government owned corporation and conduct supplementary audit of the government company, that is any non-banking non-insurance company in which union government has an equity share of at least 51% of our subsidiary companies of existing government companies. Commission shall maintain proper accounts and other relevant records and prepare an annual statement of accounts in such form as may be prescribed by the central government in consultation with the Controller and Auditor General of India. The accounts of the Commission as certified by the Controller and Auditor General of or any other person appointed by him in the behalf together with the audit report thereon shall be forwarded annually to the central government by the commission, and the central government shall cause the audit report to be laid as soon as may be after it is received before each house of parliament. The accounts of the state commission as certified by the controller and auditor general or any other person appointed by him in in his behalf together with the audit report thereon shall be forwarded annually to the state government by the state commission, and the state government shall cause the audit report to be said as soon as may be after it is received before the mm, state legislature. Critically analyze the work of NHRC and the recommendations made by commissions to the government in in December 2010. By the end of December 2020, the commission submitted 7 reports to the government along with a number of recommendations suggesting steps to make the functioning of the commission more effective for the promotion and protection of human uh, rights human rights. Some of the recommendations are the Commission recommended amendments to the Protection of Human Rights Act 1993 to ensure more autonomy of the to the Constitution so that it can grant relief to the victim or to their family members. The Commission recommended ratification of the Convention Against Torture and Other forms of cruel, inhuman, and degrading treatment or punishment adopted by the United Nations in December 1984, which came into force in June 1987. The Commission recommended for making reforms and educating the police. It recommended that serious action be taken on the second report of the Police Reforms Commission 1979, including those that suggest the insultation of the investigative function of the police from political pressure. Custodial crimes are particularly heinous and revolting as they reflect betrayal of the trust by a public servant against defenseless person. The commission recommended that the Indian Prison Act of 1894 should be revised. The commission had prepared a new all India jail manual for making reforms in the prison system. The commission in it the commission in its 1999 2000 report recommended that in order to bring about qualitative improvement in prison administration, officers of proven integrity and competence should be selected. The commission expressed to the view that to make people aware of their human rights, there is the need for an effective movement, which unfortunately is in force in spite of the existence of a large number of NGOs. The Commission stated that one of the priorities relating to human rights is to improve the status of human rights cases, human status of improve the status of the scheduled castes and scheduled tribes and the minorities. The Commission opined that the nation required a vast program of social regeneration to deal with ancient societal wrongs. The Commission suggested that the dialogue between policymakers, the security forces, and the human rights proponents be sustained. This can contribute greatly to clarity of thought and action in dealing with insurgency and terrorism. The National Human Rights Commission has entered considerably prestigious and reputation by its motto action, in which its very first action related to the Bij Behra incident in Jammu and Kashmir, and in which there were past reports of death of about 60 civilians as a result of firing by the security forces. In the first meeting of commission held on 17 November 1993, it issued suo motu notice to the government of India seeking a report on the incident. The commission has also handled some cases on alleged custodial death in such an effective manner that it has inspired the confidence of the people. For example, with regard to the case of the alleged custodial death of Madan Lal in Delhi, the commission took cognizance of the case Yumoto and appointed Sri R.C. Chopra, a member of higher judicial services, to investigate the matter. Even though the commission can matter neither render decision like a regular court nor can its decision be enforced like judgment. Nevertheless, the National Human Rights Commission cannot be branded as a weak body, and it is quite successful in solving major human rights violations.